Hello and welcome to the class. So today we are going to discuss very important acts that are Right to Education Act 2009 and Right to Information Act 2005, which are a part of our foundation course and also covers a part of Indian polity. So the learning objectives for today's class is to create awareness regarding the provisions of RTI 2005 and RTE 2009. And also we want our student teachers to empower them to promote transparency and accountability in the various working areas. Also, it will provide a legal framework of democratic rights of the citizens of India. So what is right to education? Right to education provides free and compulsory education to children in 2009, and it enforced it as a fundamental right under Article 21A. As education has been termed as a fundamental right by United Nations also, and UNESCO has included this fundamental condition in their sustainable development goals, which need to be achieved by 2030. So it is one of the key principles of the SDG or the Sustainable Development Goals, which are to be achieved by UNESCO, one of the institution of UN. So it is one of the goal which has been adopted at the international level also. So India has become one of the 135 countries to make education a fundamental right of every child. The law came to effect on 1st April 2010, except for the state of J&K, and it was implemented by Prime Minister Dr. Manmohan Singh. But if we talk about the present situation, the Union Territory of Jammu and Kashmir has finalized certain rules as per the right of children to free and compulsory education, which has been given in the Act of 2009. The administration said that it has proposed the creation of an academic council similar to that of the National Council of Educational Research and Training, that is NCERT. And Jammu Kashmir was earlier exempted from the RTE Act, which mandated the free and compulsory education for all children between the ages of 6 to 14 years. Jammu Kashmir was exempted while it still had its special category status under Article 370. And that status was withdrawn with the abrogation and the cancellation of Article 370 in April 2009. And thus, the Jammu Kashmir has become a new union territory under the purview of the Right to Education Act. Let us now take a look at the constitutional background of right to education. Originally, Part 4 of the Indian Constitution contains directive principles of state policy, and there Article 45 and Article 39F had a provision for state funded as well as equitable and accessible education. The first official document on the right to education was provided by Ramamurthy Committee report in 1990. In 1993, the Supreme Court's landmark judgment in the Unnikrishnan JP versus State of Andhra Pradesh and others held that education is a fundamental right flowing from Article 21, which says it is a right to life and liberty. Tapas Majumdar Committee was set up, which encompassed insertion of Article 21A, a subclause in Article 21. So thus, in 2002 through 86th Constitutional Amendment, right to education was included as a fundamental right in Part 3 of the Constitution. And this article made right to education a fundamental right for children between the age group of 6 to 14 years. The 86th Amendment provided for a follow-up legislation for Right to Education Bill 2008 and finally Right to Education Act 2009. So let us now take a look at the salient features of RTE Act. The first one is the Act mandates 25% reservation for disadvantaged sections of the society, where disadvantaged groups include scheduled castes and scheduled tribes, socially backward classes, the weaker sections, and the differently abled people. It also makes provision for a non-admitted child to be admitted to an age-appropriate class. So whichever class is appropriate for the certain age of the student, he will be admitted in that class. It also states that sharing of financial and other responsibilities will be shared between the central and state governments. It also lays down the norms and standards related to pupil-teacher ratios, for how many students there should be how many teachers, school buildings and infrastructure, the school working days, how many working days are required, teacher working hours per week, that is the 45 hours, minimum 45 hours should be followed by the teachers. It had a clause for no detention policy earlier, which has been removed now under the right of children to free and compulsory education, that has been amended in 2019. So it also provides for prohibition of deployment of teachers for non-educational works other than the census work, elections to local authority, state legislatures and parliament, and disaster relief. It also provides for the appointment of teachers with the requisite entry and academic qualifications which are really required for a teacher to be appointed. There are certain prohibitions also given by this act, which are: physical punishment and mental harassment will not take place. Screening procedures regarding the admission of the children of the weaker sections will not be done. There will not be any interviews taken of the parents of such children. No capitation fee, no illegal extra charges will be imposed on these children. No private tuitions by teachers will be taken. And strict action will be taken against the schools who are running without any kind of recognitions. So it focuses on making the child free of fear, trauma, and anxiety. They want to make a child-friendly system. Teaching learning should be child-centered. So based on this, there are certain achievements which have been given by Right to Education Act 2009, and these are: the RTE Act has successfully managed to increase the enrollment in the upper primary level, which was not earlier than the passing of the Act. From classes 6 to 8, there was a large cases of dropouts. Stricter infrastructure norms resulted in improved school infrastructure, and especially in the rural areas where the schools do not have their own buildings, they are running on the rented buildings. More than 3.3 million students secured admission under 25% quota norm, which was set up by this act under RTE. It made education inclusive and accessible nationwide. Removal of no detention policy has brought accountability in the elementary education system. The government has also launched an integrated scheme for school education named as Samagra Siksha Abhiyan, which subsumes the three schemes of school education, and which are Sarva Siksha Abhiyan, that is the SSA, Rashtriya Madhyamik Siksha Abhiyan, RAMSA, Centrally Sponsored Scheme on Teacher Education, CSSTE. So these all schemes have been introduced so that quality education can be brought about in our education system. There are certain limitations also to the Right to Education Act 2009, and which are: age group for which right to education is available ranges only from 6 to 14 years of age, and which can be made more inclusive and encompassing by expanding it to 0 to 18 years. So the demand for this is also going on. There is no focus on quality of learning, as it has been researched by various and presented in various reports. Thus, RTE Act appears to be mostly input oriented. So we can also quote examples from 5 states like Goa, Manipur, Mizoram, Sikkim, and Telangana. They even have not issued notification regarding the 25% seats for underprivileged children of society under the RTE. So more focus is being given over the statistics, the figures of RTE, rather than the quality of learning, rather than bringing the lack of resources which we are facing, to introduce new resources, to introduce new qualified teachers. So that is why the lack of teachers affect pupil teacher ratio, which is mandated by RTE, which in turn affects the quality of teaching. Now, what kind of steps should be taken to improve the defects or the limitations of the right to education? And these are: minority religious schools need to be brought under the RTE. More focus should be given on the improvement and the quality of the teacher training programs and the teacher training institutions. Quality of education needs to be emphasized over the quantity of education. So not only we need to enroll as much as students for increasing the figures and quantity, but also we need to improve the quality of our education. Steps should be taken to make the teaching profession attractive for the young generation, so that they don't think that the teaching profession is not for them, they go for other professional courses. Society as a whole needs to be supportive of education for children without any kind of impartiality or biases. Now we will discuss the no detention policy, which we have been discussing earlier. It was introduced as a part of the continuous and comprehensive evaluation, that is the CCE, which has not now been removed under the Right to Education Act in 2010. So under this policy, students up to class 8 are automatically promoted to the next class without being detained, even if they do not get a passing grade. The policy was to ensure that no child admitted in a school shall be held back in any class or expelled from school until the completion of elementary education. But recently, it has been removed by RTE Amendment Act 2009-19, because it is not correct that the students who are not gaining any knowledge, any skill, are just being passed till 8th standard without having proper knowledge. So this was all about the Right to Education Act 2009. And now we will discuss about the Right to Information Act 2005. So Right to Information, or the RTI, is an act of the Parliament of India which sets out the rules and procedures regarding citizens' right to information. The law was passed by Parliament on 15th June 2005, and it came fully into force on 12th October 2005. Actually, we, the people of India, pay the taxes, and from our earnings, from our honest earnings, so that we can let our nation run successfully. And we give our taxes to the government. It means that the government is responsible to serve us, and they are not supposed to serve themselves. So we should have every right to know how the government is spending money, how it is functioning, what kind of action is being taken on our complaints. We have a weapon to keep a check on the various activities of the government. We have access now to get the information regarding the functionality of the various departments of the government. So every day, over 4,800 RTI applications are filed in India. And the first country which introduced the Right to Information Act in their area was Sweden, who provided it as a legislation, enacted it as a legislation for citizens. So right to information is popularly known as RTI. It is a fundamental right given by our constitution under Article 19.1. The Article 19.1 says that every citizen has freedom of speech and expression. In 1976, the Supreme Court said that people could not speak or express themselves unless they know. So, therefore, the right to information is embedded in Article 19.1 and is a fundamental right. The RTI Act was enacted in 2005. It was passed in Lok Sabha on 11th of May 2005, and on 12th of May of 2005, it was passed in Rajya Sabha by the UPA government. It received the assent of President of India on 15th June 2005, and soon after 120 days, the Act came into force on 12th October 2005. So let us now take a look at the background of Right to Information Act 2005, how the legislation took place. Asking questions is a human tendency. The RTI is all about asking questions and also getting answers to it. So these are our right. Because our government retained the old age rules of Colonial Official Secrets Act that was being carried out in British era, even after independence, it continued to operate in a secret manner at an administrative level. The Central Civil Service Conduct Rules of 1964 also strengthened the OSA by prohibiting the government servants from communicating the official document to anyone without authorization. The factors that influence the free flow of information are democratic culture, illiteracy, and absence of useful communication tools. So this was the reason there was the need for right to information arised. No doubt that there is a need for administrative secrecy in some instances, and no one will be able to disclose the classified documents which are concerned with the national defense or the foreign policy or decisions. So it cannot be made public as it is. But every citizen has a right to know how the government is functioning. So the right to information empowers every citizen to seek information from the government, inspect any government document, and seek certified photocopies of the same. So they can have the proof for that also. Some laws of right to information also empower the citizen to inspect any government work officially or to take a sample of material used in any work. So, what is the importance of information? Information actually brings transparency and accountability, which are very much required. It helps to reduce corruption, and it will also increase efficiency in the governance for which we are paying our taxes, we are paying our hard earned money. If information is made available to the citizens, they get to know exactly how the government is functioning and what kind of things are lacking in our departments, in our government working style. So we as a citizen can uh, take the direction, try to find out what are the problems which have to be solved. We can also arise these problems through our freedom of speech and expression. So it also encourages participation of people in democracy, which is an important part of the democratic principles. So the RTI Act 2005 replaced and repealed the Freedom of Information Act, which was earlier given in 2002. So on 12th October 2005 onwards, Right to Information Act 2005 has become effective. People can seek information in the following ways. There are certain ways in which they can get the information, like they can inspect the work, they can inspect the documents or the records. They can take down the notes, extracts, or the copies of the records. They can get the photocopies of the records also. They can take certified samples of material if they want. They can obtain information in any electronic form. So nowadays, because of the digitization of everything, the government have digitized their platforms in every department. So the information, mostly all information, is tried to be given on those platforms. And RTI, we can file RTI through online mode also. So we can get the information in electronic form also. So why RTI is necessary? Because right to know about the affairs of the government is necessary for the citizens, and it will also lay a foundation stone for the healthy democracy. It will promote openness, transparency, and accountability in administration. It will support the right to freedom of speech and expression, and fundamental rights to impart and receive information will also be an important part. So the main objective of RTI is to set out a practical regime of right to information to citizens so that they can secure access to information which is under the control of the public authorities, so that we can promote transparency and accountability in the working style of every public authority. Now, who are public authority? What is the public authority? It means a body or institution of self-government which is established or constituted under the Constitution. Law made by the Parliament of State Legislature, or Parliament or State Legislature. Public authority can be formed by the notification of the government. It can also be a body controlled or financed by government. It can be a non-government body which is directly or indirectly funded by the government. Every public authority must publish its obligations within 120 days of the enactment, whenever they have been enacted by the above points, which includes the functions, duties, and the name of office bearers. So these things now are being updated on the websites of the departments. Regular updation of the websites is being done, and there is also a column for the public information officer where we can file for an RTI. So every department need to appoint a public information officer so that they can deal with the RTIs which are uh, received by those departments. So there are two features that make RTI a unique act. The first feature is it was a right-based enactment. So the right to information is a right-based enactment which is done by the Government of India. The act or laws that provide the specific right to the citizens are called the rights-based enactment. Okay, so for example, we can quote a few examples here, like right to employment, that is the Manarega schemes going on in 2005. Right to education became operational in 2009. Then there is Forest Rights Act in 2006. Right to Information Act introduced in 2005. These are all the examples of rights-based enactment which has been done by the Government of India for the citizens of India. The next unique feature is that this right has been enacted due to the pressure of society. This act was a few of those acts which were enacted with the active involvement of society and the various pressure groups which work for these kind of uh, matters, so that the government take into consideration and forms laws. For example, the Lokpal Act of 2013 was passed by the government due to the heavy demands of the people and pressure groups. So the Lokpal is an institution, a public authority, which helps in containing the corruption of the public authorities, so that these kind of things which are uh, breaking our democratic principles can be stopped. Similarly, the government passed RTI due to its demand right from the beginning. Finally, it involved all the experts from the field, such as Aruna Roy, who was an ex-IAS officer, and others to give their suggestions on the draft of the new Right to Information Act. Now let us know what is the procedure to apply for an RTI application, because as a citizen of India, we will need in some time in our future to file an RTI. So we should be aware that how to file an RTI. It can be claimed or done in two ways, that is the writing mode or through electronic mode. So what is the format of application for filing RTI? So it is to be Known that there is no prescribed format of application for seeking any kind of information. The application can be written on the plain paper. The applications, however, should have the name and complete postal address of the applicant so that any information which has to be given back to the applicant can be given back efficiently or correctly. What language is used in an RTI application? So this is very much interesting to know that it can be done in any language. It can be English, Hindi, or any official language of the area, which means language is not any barrier in filing an RTI. What are the reasons for seeking information? Do we have to specify the reasons why we want to seek that information? So there is no need for the applicant to specify any reason for seeking RTI. A person can file it whenever he or she feels certainty of any doubtful activity. Is there any assistance provided to file RTI? Yes. If a person is unable to make written request, the Public Information Officer or the PIO should render him reasonable assistance. So they can do it by writing, or they can directly go and meet the Public Information Officer for filing an RTI. What fees are charged for seeking information through RTI? So as per the RTI Act, the fees required should always be reasonable, it should be minimum, and it is mandatory for the organization to prescribe the fees. If extra fees are required to produce the information, then the same must be intimated in writing with calculation details of how the figure has been arrived by the department. So the fees is not required for citizens below poverty line category. So very minimum fees is charged for the RTI application. How much time, this is very important, how much time shall a person wait for receiving information? So it is not such that a person has filed an RTI and he will wait for many years to receive the information. Normally, the duration is of 30 days from the date of application to receive the information. But if the matter is related to life and liberty, this we have to notice that the time limit for the Public Information Officer to provide information is only 48 hours. 5 days shall be added to the above response time in case the application for information has been given to the Assistant Public Information Officer. If the interest of the third party is involved, then the time limit will be of 40 days. So these very conditions we should be aware of. And failure to provide information within the specified period is deemed the refusal to provide the information to the applicant. There are certain exemptions also to which the disclosure of information will not be done. So all forms of information are not covered under the RTI. The RTI Act has certain exceptions of disclosures, which includes information regarding commercial confidence, any trade secret, intellectual property rights, the disclosure of which would harm the competitive position of a third party unless the competent authority is satisfied that more significant public interest warrants the disclosure of such information. Information received in confidence from a foreign government, this cannot be disclosed. Information which would endanger the life or physical safety of any person, or identify the source of information or assistance given in confidence for law enforcement or security purposes, this cannot be disclosed. Information that is related to personal information, which has no relationship to any public activity or interest, which would only cause invasion of privacy of the individual, will not be disclosed. So let us now look at some important aspects of filing RTI that we must know. If more than one person asks the same kind of information, then it should be made available to all such requesters. So it is not done that only one person will be given the information. If one or more persons have asked for the same kind of information, all will be provided the information. It is advised that such records should be digitized if possible and uploaded on the website for ensuring easy access. So once the information has been given, once the RTI has been filed for certain area, then this kind of information should be uploaded by that concerned department on their websites, so that every citizen could take a look at it and there will not be unnecessary RTIs filed. The Act does not permit rejection simply because it relates to a larger number of documents. So a department cannot deny that we have to provide you with a large number of information, so we cannot do that. An applicant can ask for multiple numbers of information with just one application and cannot be asked to apply for a fresh RTI. So he can ask as many as questions in just one application, and they do not have to file different applications for asking many questions. If the information asked is comprehensive, then this can also be done. Then the PIO can request the applicant to visit his or her office personally on a prescribed notified date and time to inspect the required document or files. So in this way also the applicant can be satisfied with the required information. So this is how we have learned today about the Right to Education Act and the Right to Information Act, which is very important for us to know, and it is very significant to know about these things because we as a citizen have certain rights which we should exercise, and these are certain references which you can go through. These are the direct links of the government websites where you can go and find out more about these acts. And we have also provided with the Rajasthan government RTI web portal where you can find, and if there is any requirement to know about the answer, you can do it with just one click online. You just have to file the application number which have been given to you, the ID which have been given to you, and just by logging in you will find out that your information has been provided to you. And in case you don't, if you have not been provided with the information within time, you can certainly go to the higher authorities for your right to information. Okay, now let's move on to our next section, that is the evaluation questions. And the question number 1 is, the first state to introduce the law on right to information was? Various states have introduced the laws of information on right to information, and there were certain states who did it early and some states did it later part. So the options for that are Tamil Nadu, Uttar Pradesh, Rajasthan or Gujarat. So the correct answer is Tamil Nadu. Tamil Nadu was the first state who introduced the law on right to information. They tried to provide informations as early as possible to their citizens. The next question is, the basic objective of the RTI 2005 is? The options are to empower citizens, to promote transparency and accountability in the working of the government, to contain corruption, or all the above choices. So as we have discussed this, what are the objectives of RTI 2005? And we can make out that the first 3 options are correct, and these are the basic objectives of RTI. So all the above choices is the correct answer. Next question is, who can place an information officer under suspension? So we have to identify who has the right to suspend the information officer. The options are the President, the Prime Minister, the Chief Justice or the Speaker. And the correct answer is the President. He is the only one who can suspend the information officer. RTI Act 2005 came into force on, as we have repeated this many times, the options are 12th October 2005, 14th August 2005, 15th July 2006, 1st November 2008. And the correct answer is 12th October 2005. So the RTI Act came into force on 12th October 2005. Next question is, what is the time limit to get the information under RTI Act 2005? The options are 15 days, 45 days, 60 days, or 30 days. So this we have discussed that in normal condition, the time limit for the information is 30 days. And if there is a matter of life and liberty, it should be provided in 48 days. And if it is produced to Assistant Public Information Officer, then extra 5 days will be added to that 48 hours. And if third party is involved, then 40 days is the minimum time limit. Next question is, according to the RTE Act, children of which age group will be provided free and compulsory education? So the options are 7 years to 14 years, up to 14 years, 6 years to 14 years, or up to 10 years. So the correct answer is 6 years to 14 years of age is the criteria, or the children of that age will be provided with free and compulsory education. Question number 7 is, as per the RTE Act, private and specified category schools shall admit -% children belonging to weaker section and disadvantaged group in class 1. So what is the percentage? The options are 20%, 30%, 40%, or 25%. So the correct answer is 25%. So 25% admissions are allowed under RTE by any private or specified category of schools. Question number 8 is, in a SMC, that is the School Management Committee, the percentage of the actual parents will comprise at least. So SMC includes the parents or the guardians of the students and the management, school management. So this committee has to be made by every school as per the RTE Act. And the options are 50, 75, or 85, or none of the above. So the correct answer is 75. 75% of the actual parents will be there in the SMC. Question number 9 is, minimum number of working hours per week for a teacher are? Options are 50 hours, 42 hours, 45 hours, or 40 hours. So this we have discussed. The correct answer is 45 hours minimum. These working hours need to be completed by the teachers in a week. Question number 10 is, which country was the first to implement RTI? So the options are USA, UK, Finland, or Sweden. And the correct answer is Sweden. And the first RTI law was enacted by Sweden in 1766. It largely motivated by the parliament's interest in access to information held by the king. Finland was the next to adopt in 1951, followed by the United States, which enacted its first law in 1966, and Norway, which passed its laws in 1970. So this is how various countries have implemented RTI, and India has implemented RTI Act in 2005. So with this, we come to the end of the class, and I hope you will go through the various references and the video lecture so that you will be able to acquaint with the various acts, with various rights which we have as a citizen of India. Thank you very much, and see you in next class.